Dr. Rawlings and Nneɛma Ahyetey both have significance for the matter that we are talking about, because it was in the case in which the two of them quarreled. Nneɛma Ahyetey and Dr. Rawlings quarreled. What was the quarrel about? Nneɛma Ahyetey had sued Dr. Rawlings, who had defeated him in the parliamentary elections at Korle Klottey, on the basis that she was not qualified and therefore ineligible to be elected as member of parliament by anybody, and therefore the party NDC should not put her up. The issue was that Dr. Rawlings didn't have a nationality challenge, but she was not a registered voter. She had not been a registered voter, which is one of the principal qualifications for one to contest parliament. You must be a registered voter. You must be a citizen of Ghana only, as it were, among other regulations, other laws in there. And Nneɛma Ahyetey contested that Zanetta Rawlings was not a registered voter. It turned out that Dr. Rawlings was actually not a registered voter. The matter went before the Supreme Court. It was in this matter at the Supreme Court that it was given a clear understanding of at which point does the calculation begin. So we'll get there. We are not in the story. We'll get there. And that's why I have Dr. Rawlings and Nneɛma Ahyetey here. Adamu Sakande is important, very, very important, because I'm going to talk about him. Now, Adamu Sakande, here, may he rest in peace as well. He gallantly won the elections of 2008 in a very difficult constituency, Boku, where Mahama Yariga is MP. Now, Adamu Sakande on your screen now won that election. Okay. And that election was lost by the presidential election was won by Professor Mills on December 7th, December 20th, and I think January 3rd, the 3 rounds of election. And Professor Mills became president, and therefore the NDC were in administration. A writ was filed against Adamu Sakande's election on the basis that he was a British citizen. And the court found out that indeed he was a British citizen. Adamu Sakande was therefore disqualified from being a member of parliament. A by-election was occasioned, and the by-election was won by the NDC. Adamu Sakande was prosecuted. And that's where we'll get to that. We'll get to that today, because the offense that will make a high court determine that you are not a citizen of Ghana only, and therefore you are ineligible to contest. Embedded in that is the fact that you may have given information on the Electoral Commission's form that you are, and there's a caution on the form that any information found later to be untrue shall be used against you in a prosecution. So what happens is that if you find yourself in this kind of situation that Mr. Kwesi has found himself, you are headed for prosecution. And that's really what happens. You're going to be prosecuted for the offense of disclosing falsehood to a public document, to a public official, like Dom Levo, who disclosed wrong age, that kind of thing. So this is how it is. Once you are found ineligible on the basis that you gave wrong information on the Electoral Commission's form, you are due for prosecution. We know that the Honorable Kwesi is already under prosecution. He's pleaded not guilty. The prosecution has begun, and they are prosecuting him for the offenses same as Adamu Sakande. And I look at Facebook tonight and I'm wondering whether people have forgotten or whether people don't just want to say it. This is not the first time Ghana is finding itself in this position. This is not the first time. This one has dragged on, especially this one has dragged on because there's been resistance here and there. And you will see that as we read the Supreme Court ruling, how the judges are talking about the resistance that came in that was unnecessary when a man was aware that he had filled the form wrongly, indicating that he was a citizen of Ghana only. So Adamu Sakande is the first one. It's precedent. He was an NPP person. He won the election, and it was said that he was a British citizen. In fact, not that it was said. As a matter of fact, the court found out that he was a British citizen at the time that he filed the nomination. By the time the conversation was being had, he was no longer a British citizen. The same situation as we're hearing people talk about today. And tonight we'll show you also the rules in Canada, where Honorable Kwesi was a citizen of. What the rules say in terms of renunciation of your citizenship. We'll show you all of that. Okay, but Adamu Sakande's part is very, very important. This is not the first time it happened. Incidentally, we have to say, it would appear that the Justice Kulendi, who wrote the majority opinion of the court, was at that time, as they say, as he then was counsel for Adamu Sakande at some point. It would appear so. But Justice Kulendi was counsel for Adamu Sakande at some point. So that's a very interesting mix. And then you saw the judgment that he wrote. If you haven't seen it, you're going to see it here. We have isolated the most important parts to show you. So this is very important. Adamu Sakande's precedent is very, very important. And all political commentators cannot lose sight of it. These people criticizing the court for doing this and doing that. The court, on the same basis, as the lawyers say, Adamu Sakande's matter and Kwesi's matter falls on all fours. That means they are exactly the same thing. And I don't know what is wrong here, but this is exactly the same thing. Adom-Otchere came in, won the election, had issues with citizenship. He was removed and prosecuted. Eventually, he died. May he rest in peace. It's exactly the same thing. The questions that are being asked, if you look at the affidavit that was filed by the lawyers who challenged Kwesi, and if you look at that which was filed against Adom-Otchere, they are identical. Very, very identical. Because it's really the same thing. But when you see people who know this matter, and who understand, and we are building a society, and come to criticize the Supreme Court's ruling, pretending this has never happened before, it is just totally shocking. For young people who may not remember or who did not acquaint themselves with the news at that time, that's okay. But for those of us who remember Adom-Otchere, he was recently buried last year, who remember Adom-Otcere's matter, we shouldn't pretend that we don't know. Then you find serious politicians, right? It's a travesty of justice. What is a travesty of justice? The Supreme Court, the High Court, and the Court of Appeal have ruled the same way as they ruled in the Adom-Otchere case. Is it that if it feels on another one is better, and if it feels on us it is wrong? Is that the kind of politics we are playing? This is not the first time we are seeing this in this country at all. Squarely, maybe God is just nice to us, or God wants to expose our dishonesty, because the matters are the same. The courts ruled one way in Adom-Otchere. They've ruled the same way in this one. And we say it's hypocrisy, is that it's a travesty of justice. We will not forget history. Some of us will always remind everyone of the actual factual history. And we ought to be guided by it. So what we have to understand is that the Assin North constituency, is it Assin North we are talking about? Previous results shows in the Assin North. Okay. It's Assin North we're talking about. It used to be one constituency with Kennedy Japan, the one you know, the member of parliament, Kennedy Japan's constituency. It was divided at some point, I believe in 2004. And then this Assin South, I think. And then, we'll find out. He took one of the Assin, and this is the other. That's the history of the constituency. So it's in the central region. You know that central region has different kinds of tribe, fundamentally Fantis, but there are also the Hutus, and so in Winneba and that kind of place. The people in the Assin Fosu area and the Assin area are thought to be Ashantis, so they call them the Twi Fantiful. They speak Twi, they don't speak Missing there, they speak proper Kumasi Twi. That's them. That's the culture of the people there. They also have quite a bit of business there, mining and stuff in the area. So there's an influx of people from the northern part of Ghana who are also very present there. You find all that mixed in the Assin constituencies. So that's the history of it. So in 1996, this constituency was won by the NDC. And then since then, in 2000, 2004, 2008, it was all won by Kennedy Japan. At that time, it wasn't the Assin that we know today. At that time, it was one constituency. And then since it got split, I believe in 2012, since it got split, this has been the outcome. In 2012, it was won by the NDC. In 2016, it was won by the MPP. In 2020, it was won by the NDC, the one we are talking about. And so we put there whether or not there's a by-election in 2021. Let's look at the details of the results that have been coming in from the Assin constituency over the years. These are the data that has been coming in from there. So year 2012, a gentleman called Ambre Samuel, he pulled 14,000 to win it for the NDC against the MPP's Ebenezer Kubi, who pulled 12,000. So you see that's kind of close, 51% to 54%, 12,000 to 14,000. That was in 2012. Then in 2016, the MPP changed its candidate. Abner Droa Mensah became the MPP's candidate. Ambre Samuel was the incumbent member of parliament. He went down 4,000, looks like, with earning now 10,751 votes against Abner Droa's 15,553. So Abner Droa is the incumbent member of parliament. The difference in 2016 was 4,800. The difference in 2012, 2,000. And the difference in 2012 and 2020 is quite identical. In 2020, Abner Droa is still the candidate for the MPP. James Kwesi comes in at 17,498, representing 54% of the total votes. And Abner Droa comes in at 14,000, the difference being 2,705. So that's how the demographic, that's how the data of the results look like in the Assin constituency that we are talking about now. This is the story. So we get into the story proper. So here are the results of what we are talking about. So you can put it in proper context. Okay. So now we have to understand that the Constitution has delimited a procedure for challenging parliamentary election results, and a separate procedure, a different procedure for challenging presidential election results. For parliamentary election results, I believe we're here in Article 99, it says that the High Court shall have jurisdiction to hear and determine any questions whether a person has been validly elected as a member of parliament, or of the seat of a member of parliament has become vacant, or B, a person has been validly elected as a speaker of parliament, or having been so elected has vacated the office of the speaker. So the High Court shall have jurisdiction in these matters. Okay. A person aggrieved by the determination of the High Court under this article may appeal to the Court of Appeal. Full stop. So that's where the issue is. And the Supreme Court dealt with that. So when it's a parliamentary election petition, the Constitution in Article 99 enjoins you to go first to the High Court, not to the Supreme Court. In a presidential election petition, you go straight to the Supreme Court. In the presidential election petition, the High Court has no jurisdiction. The Court of Appeal has no jurisdiction. There is an exclusive jurisdiction and an original jurisdiction held by the Supreme Court of Ghana under the Constitution. I believe it's in Article 66. We'll get there, or something like that. We'll get there. So that's for presidential election. That's not for parliamentary election. In parliamentary election, the matter is different. So we all used to election petitions, watching it on television, it being aired and by TV, and it being prosecuted in the Supreme Court. So we kind of used to that. No, that's for presidential election petition. Parliamentary election petition does not go to the Supreme Court at all, as we will find out. It doesn't go there at all. In terms of its travel process, the Constitution says High Court and then Court of Appeal. So it says a person you can go to the High Court to challenge whether a person has been validly elected as a member of parliament, and where you are aggrieved by the determination of the High Court under this article, you may appeal to the Court of Appeal. So now let's discuss then, Mr. Kwesi, you can put back the Court of Appeal decision now. Let's look at Mr. Kwesin's matter. So what happened? So after the process, his opponent went to the Cape Coast High Court and filed a writ at the Cape Coast High Court. The Cape Coast High Court looked at the matter and made a determination that Mr. Kwesin is ineligible. He's not qualified. He shouldn't have run the election because he gave wrong information. He was still a citizen of Canada at the time that the check was done. And now we'll go to when and where the check was done. This is the Court of Appeal document. So after the High Court, an aggrieved person can go to the Court of Appeal. So what happened at the Court of Appeal? So they indicated an indication to appeal, but they did not file any process to appeal. I can hazard a guess why. You see, this matter's determination by the High Court is not a determination of political or legal philosophy. It's a determination based on numbers and dates. So it is difficult for anyone to override the High Court's situation. The simple question that is before the court, whether or not Mr. X, in this case, Honorable Kwesin, at the time that he filed the process, and the Supreme Court has determined when that check is done. We'll go to in the Zaneto case, when that check is done. Supreme Court says the check is done at the time the Electoral Commission opened nominations and at the time you file the Electoral Commission's document. You may not be eligible at the time you are filing your party's document. You may not be. But you have to be eligible at the time you are filing the Electoral Commission's document. That's a clear ruling of the Supreme Court in the Zaneto matter. If we have time, we'll look at it as well. But the Supreme Court held that clearly. So the High Court has a simple test. You take the time that he filed the nomination at the Electoral Commission and you look at that date whether or not he was still listed as a citizen of another country. It's as simple as that. Any court can come to that very simple conclusion. Therefore, it's difficult for an appeal to overturn the position of the High Court because this is not a narrative. This is not philosophy. This is not the discretion of the judge. This is not interpretation of rules and regulations. This is mathematics. It's whether on this date this person had a citizenship, yes or no. It's plain and simple. So when the High Court makes that determination that, Mr. Kwesi, we are sorry, on the date that you filed the process, here is your Canada process, you were still a citizen of Canada, or you had not finished the process of renouncing your Canadian citizenship. That's the end of the story. It's a fait accompli. No court can overturn that because the verdict is based on mathematics. It's not, it's not based on a judge's philosophy, so you can otherwise philosophize. Okay, here is the Court of Appeal situation, and I'm putting this out because I've seen tweets that say that the matter is still before the Court of Appeal. It hasn't run the full course. It has run the full course. The determination of whether or not Mr. Kwesin was a Canadian citizen at the time he filed the process has run its full course. This is the Court of Appeal's decision, and this is now the court's decision. Okay. This is her registrar certificate indicating that the appellant has not complied with the requirement of Rule 20 Order 1 of CR 19. From the records available on this appeal, the Form 6 was served on the appellant on 13th October 2021. The registrar certificate for non-compliance was issued on 13 January 2022, 3 months after the Form 6 was served on the appellant. This is very significant. So those who say that the matter has not gone to the Court of Appeal, this is the record that shows that the matter went to the Court of Appeal. I told you we're going to serve you here with truth. We have nothing to to embellish. This is the truth, okay? Yes, so this is what the court is saying. Now, I can understand why. Now, the registrar of the court indicated on 13th October to the appellant that, look, you have not filed your documents according to Form 6 in the regular way in which you should do it. That's what the registrar indicated to the appellant, Honorable Kwesi, and Mr. Chikata, his lawyer. It turned out that as of 13 January, since October to January 2022, they were still yet unable to file their documents. And I can understand why, as I was telling you, what are you going to appeal in this matter? The matter is a matter of calculation, a matter of dates. Nothing is going to change. So really, many lawyers will look at the High Court decision and will decide that there's no point, there's no need to appeal in the matter, isn't it? Okay, so let's now get to the details of the matter. Let's go to the Canadian document. Mr. Kwesi's Canadian document. Because of time, we're going to skip the Supreme Court on the Zanetti Rawlings one. Simply, the Supreme Court said that the time you make the decision is when the Electoral Commission documents are brought in, you file it. We don't have time to show you that, but we'll skip it. So let's move on. All right. So this is the Citizenship Act of 1985. It's from Canada, where Mr. Kwesi comes from. It says, if an application under subsection 1 is approved by the minister, application under subsection 1 is an application to renounce your citizenship. If an application under subsection 1 is approved by the minister shall issue a certificate of renunciation to the applicant, and the applicant ceases to be a citizen after the expiration of the day on which the certificate is issued or any later day that the certificate may specify. Yes. So he ceases to be a citizen on the day that the certificate is issued. So the simple calculation of the High Court was that you began the process. You know that this is the Citizenship Act of Canada 1985 indicates that your renunciation is complete when you have received the certificate. The question the High Court will be asking Mr. Kwesi and his lawyers is that, had you received the certificate of renunciation at the time you filed and answered that question, whether or not you carry a citizen of Ghana only, answered it in the affirmative, or if the question was, are you a citizen of another country, answered it in the negative. That information that you gave to the Electoral Commission, which allowed you to be processed, to become a parliamentary candidate, was false information, and the law will say that you knew that it was false, or that you ought to have known that it was false. That's the problem that Mr. Kwesi was facing in the court, I believe. So this is the facts from Canada itself, where he's coming from. This is what he ought to have done.